Hello everyone, my name is Anurag Roy and you are watching Law and Speaking Skills. So today we will talk about a very important topic. It's play a very important role in Indian Penal Code, and I am talking about general exceptions. Yes, if you have studied Indian Penal Code or you are a student of law or just a new person, so this is a very important topic for you and it will make it easier for you to understand Indian Penal Code. So without wasting the time, let's get started. So basically, if before we go further into the details of every section, we must know that what is general exceptions is all about. Well, in Indian Penal Code there are several sections, like section total 511. So each and every section approximately talking about offenses and its punishment. But if there is any offense or punishment committed by a person under a situation and circumstances which is provided under chapter 4 general exception, then that person will not be liable for the penalty or punishment. So in this video we will only understand those situations and circumstances under which if any person commits an offense, he will not be liable for that penalty of a offense. The act done by a person or by mistake of fact believing himself bound by law. Nothing is an offense which is done by a person who is or by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. Well, this is quite difficult for the first time to understand, but we will take an example of illustration right here. If there is a person whose name is like A, he is a soldier and he is ordered by his superior officer to fire on a mob. Mob means a group of people, and he fires. Then if any person dies, that soldier A will not be held responsible. Why? Because he does a work or an offense on the order of the superior officer, not by himself. With section 77 and 78 related to judges, act of judges when acting judicially. Let's first read it out. Nothing is an offense which is done by a judge when acting judicially in the exercise of power which is or which in good faith believes to be given to him by law. So here it is quite simple. When a judge acting judicially in the exercise of any power or which in good faith he believes to be given to him by law, means any person who is a judge who think that according to law he has certain power to do certain act and he does that act, and due to that act some offense is committed, then that judge will not be held responsible. Why? Because he exercising that power acting judicially and in good faith. Section 78 talks about act done in pursuant to judgment order. Yeah, there are judges who provides orders and judgment, which is known as judgment or order of a court, and that will be valid. But any person acting under that judgment or order will not be held responsible for any act if any offense is committed. Why? Because he is doing that act or work under the judgment and order of the court. The 79 talks about act by a person justified or by mistake of fact believing him to be justified by law. 76, remember, 76 was talking about a person who is bound by law, and 79 is talking about a person who is justified by law. This is the difference in these two sections, and to some extent they are quite similar to each other. Let's come to section 80, accident in doing a lawful act. Let's first read it out. Nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in the doing of lawful act in lawful manner by lawful means with a proper care and caution. That's a simple section which says that you are doing a lawful act in lawful manner by lawful means and taking a proper care and caution in doing any act, and if in performing that act by misfortune and accident some offense is committed, you will not be held responsible for that. Act likely to cause harm but done without criminal intention and to prevent other harm. Let's first read it out. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm, if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm for the person or property. Well, this section is quite simple as well. We first take an example. Here we are saying that if a harm needs a criminal intention, but the harm has been done without criminal intention in order to prevent other harm, then that offense will not be considered as a penalty for you. If there is a boat and B another boat, and A found himself in a situation that he has to hit B without injuring C, let's say another boat C. I'm making a different example, not this example. There are two boats A and B, and A finds himself in a situation that he has to run down the boat B in order to save C. That's the third boat. Then that person will not be held responsible if somehow he run down the boat B. Well, section 82 is quite simple. Any person who is under the age of 7 years, he will not be liable for any offense and penalty if he does an offense. Section 83 talks about a person who is above 7 years but under 12 years of immature understanding. He will not be held responsible for a crime if he does such act. Section 84 is also talking about the same, but there is an unsound mind. A person of unsound mind will not be held responsible if he somehow is not able or incapable of knowing the nature of the act what he is doing. It is talking about, let's first read it out. Act of a person incapable of judgment by reason of intoxicated cause him against his will. Any offense committed by a person, it simply says any offense committed by a person who is incapable of making any judgment, and the incapability arises due to intoxication caused against his will, then that person will not be held responsible for an offense or penalty. Section 86, offense requiring a particular intention or knowledge by one who is intoxicated. We first read it out. In case where an act is not an offense unless it is done by particular intention or knowledge, a person who does the act is in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing intoxicated him. Yeah, it simply says that if a person commits an offense which requires particular intention and knowledge, but he is intoxicated against his will or against his knowledge, then that person will not be held responsible. Both 85 and 86 are quite similar to each other, but the difference is there in section 86 there is a particular intention and knowledge, and not in section 85. Section 87 talks about an act not intended or not known to be likely to cause death or grievous hurt done by consent. Let first we read it out. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given their consent express or implied to suffer that harm. It simply says that if there are two persons A and B, and A and B both have given their consent and both are above 18 years of age for certain act, and one who has no intention to cause grievous hurt or death somehow commits that act, will not be held responsible. Section 88, act not intended to cause death done by consent in good faith for the person's benefit. Anything will not be held responsible for any penalty or punishment for the only thing that is done for the person's benefit. If any act is done for the person's benefit and it somehow commits an offense, will not be held responsible because there is no intention to cause death, but the only intention is for the benefits of person. We can take an example like we have faced many times or some of the times doctors in our life, and this example is talking about the same. It says that if there is a surgeon A knowingly that a particular operation likely to cause death of Z, he knows that a operation will cause the death of Z, but not intended, but he has no intention to cause death of Z, but in good faith for the Z's benefit he performs an operation with Z's consent, who has consented that operation. Then A, if somehow commits death of Z, will not be held for any penalty or punishment. '89 is talking about an act done in good faith for the benefit of insane person by reason of consent. If there is a child or insane person, or if there is an insane person, then the consent of his guardian has given to a person who is performing in good faith an act for the benefit of child or insane person, and somehow he commits an offense in performing an act in good faith for the benefit, he will not be liable for the penalty or punishment. 90 talks about the consent known to be given under fear or misconception. Consent basically given by a person to another person to perform an act or activity. Here in this section the consent of insane person is provided, consent of a child is provided. Not so important. Section 91 also related to 88, 89 and 79. It basically what does, it excludes the acts which are offenses independently of harm. 92 is basically talking about an act done in good faith for the benefit of person without consent. Remember section 89 where we talk about the performing of an act for the good faith for the benefits of person. Here the thing is without consent. The only difference among the section 89 and 92 is with here in 92 there is a word used without consent, and the rest of the section is quite similar to that of 89. 93 is talking about communication made in good faith. If there is a communication made to another person, let's say there are two persons A and B. A made a communication in good faith to B, but B, due to that communication, suffers any harm, then A will not be held responsible or liable for any penalty. Let's come to section 94. It talks about an act which a person is compelled by a threat. It is quite important section, like let's we understand it in detail. Like there are two exceptions made here, like murder and an offense against an state. Except these two offenses, if anybody puts a gun on the head of any person and said him or direct him to commit an offense, and he does an act on whose head the gun is loaded, then the person will not be held responsible who commits the act under fear. But if he does an act of murder, or if he does an act of offense against a state, that person who is under a fear will also held responsible and penalty for an offense. That come to section 95. It basically talks about a slight harm. If we first take an example, if there are two persons A and B, A commits an short and slight harm to B, and that slight harm should be a harm where no person of ordinary sense or temper would complain of. Hi guys, I hope you like this video. Don't forget to subscribe and like this video. Subscription is like lifeline for me as I have just started this channel. Please let me inspire for making new and more videos. So please subscribe and like. Thank you.